Don't stop me.
All right, this is case number 244133 FY Appearances Counsel.
Joanna Carey for the people.
I'm Jeff Harrison. I'm the attorney of record for Mr. Graves thus far.
And Mr. Grames joins us as well. Sir, is it Grames or Grams?
Graves.
Grames, all right. And we are scheduled for a probation violation. However, yesterday, Mr. Harrison filed a motion to withdraw as counsel, so I suppose it's appropriate we take that up first. Ms. Carey, did you receive that motion? Did we get her a copy of that? Ms. Carey, have you had the opportunity to review that?
I did, thank you.
All right. Mr. Harrison, I'll turn it over to you.
Well, in a sense, Your Honor, what we're anticipating doing is really killing two birds with one stone. It is anticipated that Mr. Graves will be participating. At this point, it's hard to determine. He is a fact witness in the other case that's noted in here. It would be reasonable for us to conclude that his position will be averse to our client in that matter. The other thing that I would hope to accomplish is not only that appearance of a conflict, but the fact that Mr. Graves has also expressed his preference that I not be his lawyer. I think for a number of reasons, it's appropriate to simply allow us to withdraw. I don't want it to be said later on, that other case, it's a CSE1 case and it will likely go to adversarial proceedings. I don't want it even the appearance that I somehow gained some knowledge with regard to Mr. Graves that I would use in that proceeding is cross-examination or whatever. I just don't, it's a bad look. Secondarily to that, I'd like to respect his preferences as well. Thank you.
Ms. Carey?
Well, I don't know much about the other case. Brand new. Brand new. Signed in Barnes, it's a CFC. And he's over here, so I don't know what the conflict is, other than he might, as a witness. I don't know if there's been a breakdown in relationship between he and Mr. Harrison or not. He didn't express that. Other than it's his preference not to have Mr. Harrison, but I don't believe they get to choose. That's the court appointed. So with that being said, I would.
So, Mr. Harrison, let me ask you, so the allegation in this case is that he violated the no contact order by trying to enter the victim's residence. Is the victim in this case the victim in the other case? Is the victim in this case tied to the other case at all?
She is not. The problem comes in that in the other matter, the file that's noted in our motion, Mr. Graves is alleged to have acted in a supervisory capacity over the alleged victim who has mental challenges and lives in a group home.
Is he an employee of that group home?
I believe so. Or some company that provides services to that home. I think it would be inappropriate for me to learn things about his state of mind, perhaps, and or condition that would reflect negatively on his ability to perform those services.
So the concern is what you might learn in defending this violation
Exactly.
might rise to something that you're going to use to impeach him at a criminal trial should it get to that.
And I think that that's enough of an appearance of a potential conflict to stay out of the way.
And is the reason that Mr. Grames is requesting that you be removed that reason, or is there another reason?
I think he just did not have what he thought was a satisfactory experience last time.
Okay.
He didn't say anything to me. I've just heard he talked to my staff. And
Mr. Grames, is that true that you also want Mr. Harrison removed?
Yeah, the first case I had with him,
We don't need to get into the details for that, but
Oh.
is it your desire to have him
Yeah.
removed? All right. All right, the court does find based on the potential of impeachment of the prior proceeding and the other case that's referenced in the court file or in the motion to withdraw, I do believe it's appropriate to grant the request to withdraw. And Mr. Harrison, has your office already taken steps to try to get somebody lined up?
I believe we have contacted Mr. Cherry, but I don't know. I don't want to misrepresent anything to the court. I don't know.
All right. All right, we'll grant the request. Can you get an order sent over to us for signature?
There is an order attached to the bottom of that. It simply says it is so ordered. If you want to do it that
See
way.
that? We can do that.
Excellent. Thank
Any
you.
objection to that, Ms. Carey?
No.
We can get him placed and get this matter back on relatively quickly.
Mr. Graves, just so you know, that means that your probation violation won't be heard today. Just so you're aware of that. We're gonna get it back on as soon as we can. Something here. Okay. We will get it set just as soon as we can.
Thank you.
Anything else for the record, counsel?
Nothing further.
All right, Mr. Graves, you can go with the deputy. All right, for driving while license suspended, denied or revoked, and operating a motor vehicle without security. Ms. Nyman, if you are found guilty, you could be sentenced to what you could have been sentenced to under the original charge that you pled to, which was operating while intoxicated as a second offender, so up to 1 year. Do you understand that? All right.
Your Honor,
Yes.
if I recall correctly, I believe I dismissed the second count of probation violation, no insurance.
Did we do that?
I did that in
Okay.
the underlying case, and I believe I did that in the probation violation.
All right, then we will, okay. Then we will just go forward then on the driving while license suspended. Mr. Hartel, how are we proceeding today?
My client would do admissions to this as well, Your Honor.
All right. Ms. Dahl, any objection to that? All right. Ms. Nyman, will you raise your right hand, please? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
All right. Is it true that you plan to plead guilty to the probation violation of operating while your license is suspended, denied, or revoked? And has anybody promised you anything in order to get you to do that? Has anybody threatened you in any way? And is it your own free choice to do that?
Yes.
You were placed on probation in this court, actually placed in sobriety court with a probation order to run side by side with that sobriety court for a period of 24 months back on April 3rd of 24 by Judge Van Alst. And as a condition of that probation order, is it your understanding that you were not to violate any law?
Yes, sir.
And back on December 12th of 2025, were you stopped in the city of Cadillac for driving while your license was suspended, denied, or revoked?
Yes, sir.
Do counsel believe defendants provided the factual basis in which to accept the plea and that the court rule has been complied with?
Yes, Your Honor.
Yes, Your Honor.
The court agrees, Ms. Nyman, I find you guilty of violating your terms of probation by driving while your license was suspended, denied, or revoked. Along with that, although not a listed violation, is being terminated from the sobriety court program. I know we don't have a recommendation in this case, or at least I haven't received one from the probation department. I know there's been some hiccups along the way as to how Ms. Nyman should have been proceeding after being terminated from sobriety court. Do either party request an adjournment to get a recommendation, or are you both comfortable moving forward without a recommendation from the probation department?
The defense at least would prefer to go forward today.
All right, any objection to that?
No, Your Honor, so the prosecution.
All right, allocution then, Mr. Hartel?
Yes, Your Honor. I would ask the court to factor in that even though there's been a finding, my client was obviously on probation even if it was sobriety court for a significant chunk of time. I believe she was almost near the end of it. I can't immediately recall if she had any time served prior to that. Were you launched at all? Okay, so a little bit of time served as well. I do believe that the fact that she's lost the benefit sobriety court is sufficient punishment under the circumstances. I do recall her factual basis from the other day. I won't regurgitate it verbatim, but I'm sure the court recalls it as well. Because we went into a little bit more detail at the prior hearing. But what I will say is I know that she wants to be there for her children. She's motivated privately to be invested in her own sobriety. She doesn't feel the need to necessarily have supervision to do that. If the court was on the fence between a little bit more supervision or a jail, then obviously she'd prefer that. But again, she was supervised for a decent chunk of time with at least a few days' time served. Thank you.
That reminds me, Mr. Hartel, Ms. Dull, did you each receive a copy of a email that the court received yesterday?
I did, and I discussed it with my client privately.
Okay, I just want to make sure you had it, so.
Yes.
I have your honor as well.
Okay, allocution then, Ms. Dull?
Your Honor, I would like to ask the court to keep Ms. Nyman on probation for the remainder of the term, however short that may be. I believe it's less than 3 months. The reason I would like to keep her on probation is because her losing sobriety court is probably very difficult for her. I know that she was pleading with the court to keep sobriety court as one of her only requests at the last probation violation for her sobriety court violation. So I could tell that her sobriety court was very important to her despite the issues that she had in sobriety court and ultimately was terminated. I believe at this point, she is at a higher risk of relapse than she was while she was in sobriety court. And I do recall she did relapse at least once while in sobriety court. So considering her losing what she said was something that she was very proud of and was very important to her, she might be at risk. So I'd ask the court to continue her on probation and monitor her through random testing to make sure that she maintains her sobriety for however short of a time she still has left on the probation term. Thank you.
All right, thank you. Ms. Nyman, you have the right to address the court prior to sentencing. Is there anything you'd like me to know?
I would like to be on probation until April. I think that would be helpful for me. I really want to be with my girls. I want to continue working and taking care of everything that we have, and I would be very thankful if I was left on probation until the end of my sentence.
All right, the court agrees that I think it's would be beneficial to keep you on probation. I want to make sure that I know the loss of sobriety court was a huge setback, so I want to make sure that you're still receiving at least the majority of the services that we can give you to help you get through the next couple of months. So I will continue probation with the terms as previously set. Have you met with Ms. Bismack at all yet?
No, I called the day, it was last Wednesday, because I thought that I was supposed to be reporting to her and there was nothing for me down there. And then I spoke with Danny, the court administrator, and
Yep.
No, I haven't had any contact with her, just Rosie.
Okay. I know we've communicated with Ms. Bismack a little bit, or my staff has. So what I'm going to ask you to do is, once you leave here, you can go out to the front window where you checked in, get this order of the probation violation, and then go downstairs and get checked in with Ms. Bismack's office. Okay? All right. Good luck.
Thank you.